Hi, I'm immigration attorney Heather Poole. I'm speaking to you today about common mistakes and how to avoid them in your immigration case. Be sure to check out our 5 harmful mistakes to avoid your immigration case, our first part of this video series. Always consult a competent licensed immigration attorney about your particular case to determine your options. Mistake number 6, not appearing at CIS for your green card interview or for your court appearance for the master calendar hearing when you are in deportation proceedings. If you fail to show up for a green card interview, your case can be denied based on abandonment and potentially even fraud if the other spouse shows up and implicates you. In a removal proceeding, if you fail to show up, the judge will issue an in absentia order. This is a removal order that bars you from any relief, even if you're married to a U.S. citizen, until you have been outside of the United States for at least 5 years. There is no waiver to an in absentia order. Besides this, you would also get a removal order of 10 years that would run concurrently. There can be some very harsh consequences to not showing up at interviews or court appearances. If you are worried about showing up to an interview and what your options are, you should always seek the counsel of an immigration attorney before attending the interview. Mistake number 7, comparing apples with oranges. Immigrants tend to compare their case against someone else's case, someone they know or someone they've talked to on the internet in one of those useful forums. It's understandable that you want answers and hope that someone else's case in your circumstances has had an approval. But be cautious. No cases are exactly the same. It's like comparing apples and oranges. Immigration law is very fact-specific. When comparing your case to another person's, you have no idea if their facts exactly match up with yours. Having no idea about the differences in their prior immigration history, their family history, what has been filed for them in the past, their immigration entry history into the United States, what arguments they've used in their case, and other intricacies that affect whether their case was approved and yours will not be. Be very careful about relying on information that you find from a stranger over the internet, especially someone who is not a lawyer and who advocates that you file your case yourself. There's a lot of misinformation on the internet, as well as good information, and it's hard to decipher which is good and which is bad. If the case seems simpler and easy to do yourself, I still suggest that you talk to an immigration attorney, because you know the old adage, if it seems too good to be true, it probably is. The thing with other people on the internet who have gone through similar circumstances, they can cause you an unneeded anxiety, cause you to question your own attorney and micromanage your own attorney. Be very careful who you listen to on the internet. Mistake number 8, overstaying your visa or voluntary departure grant. When you overstay your I-94 card period that is granted to you when you enter the United States, you start to accrue unlawful presence. You could be barred for 3 or 10 years, depending on how long you've been in the United States without the right to be here legally or without a valid visa. If you're here unlawfully present, you're not eligible for a visa in the United States and would be subject to unlawful presence bars the minute you left the United States to go pick up another visa at the interview at the consulate. Even if it's a green card at the consulate, if you leave, you can still trigger one of these bars. Unlawful presence is very serious, and you should really track how long you've been in the United States before you make any travel moves or visa application. Similarly, it's a big mistake to overstay your voluntary departure grant. Voluntary departure sounds like a great option for someone who is facing a removal. Voluntary departure is a special type of relief available in immigration court, where the judge allows you to return home, usually within 60 days, as long as you do so voluntarily and you pay for your own plane ride home. The judge gives you this option instead of a removal order, so you don't have a removal order on your record. Voluntary departure then would allow you to reapply for a new visa abroad without having a removal order in your history. Otherwise, if you had a removal order issued against you, you could be kept outside the United States for 10 years. Many people like the idea of getting voluntary departure because it sounds better than a removal order, but they don't fully understand the consequences of overstaying the voluntary departure grant, of overstaying the 60 days that the judge usually gives. Problem is they just don't leave the United States. When you overstay a grant of voluntary departure, you are ineligible for applying for a green card in the United States for 10 years. You are also ineligible for cancellation of removal and other common forms of immigration relief in that 10-year period. Mistake number 9, traveling illegally back and forth across the border between the United States and another country. This can pose a serious problem for what immigration benefits you can apply for in the future because you've been going in and outside the country so much. You may expose yourself to the unlawful presence bars as well as the permanent bar. The permanent bar requires you stay outside the United States for 10 years if you trigger it, and there's no waiver for the permanent bar. It's very important you talk to an immigration attorney before traveling. Mistake number 10, an immigrant showing up at the local CIS immigration office when the immigrant is out of status. Most CIS buildings also have an ICE detention department and officers ready to arrest immigrants at interviews when they do not qualify for the benefit they are seeking. When you file an immigrant visa case, the mere act of filing the case does not grant you any type of legal status. For example, if a spouse of a permanent resident files an immigrant visa for their spouse, it is risky for the immigrant spouse to go into the local office for an interview if they have no underlying visa besides the one filed by their husband. The filing of the immigrant visa by the husband does not grant the immigrant spouse any kind of legal status. The spouse has to have had underlying legal status, such as a temporary visa or another visa, that gave them status all the while that their adjustment of status, the green card process in the United States, was pending based on the new marriage. Otherwise, the immigrant visa is not going to be evidence that they can apply for a green card. The immigrant can be detained at the interview. Definitely consult an attorney if you have an immigrant visa interview based on marriage to a U.S. citizen or permanent resident, and you also have a prior removal order in your history. There is also risk of attending the interview and whether it is worth the immigrant visa being approved for you to be exposed to immigration where they can reinstate your order. CIS can pull in ICE officers to detain the immigrant spouse and execute the outstanding order. It is important to consult an immigration attorney if this is your fact scenario, to know what you're getting into and whether it is safe considering the pros and cons of your situation to show up for an immigration office to ask for information or even for a green card interview. Talk to an attorney. Mistake number 11, not taking your case seriously. Many people do nothing at all hoping that the law will change. Hoping that you will not get picked up because you're waiting for the law to change, failing to consult a competent lawyer about your options can create a lot of problems. Certain types of immigration relief have deadlines, and you may be eligible for a benefit now. Another way people do not take their case seriously is not being prepared for the actual immigration interview. This includes not providing the correct documentation and just talking too much at the interview. Questions are opened up to go into other areas that you're not prepared for. It's extremely important to speak with an immigration attorney about your case before you start it to determine what options you could face that could result in a denial or even a removal from the United States. If you need my help, feel free to call me or complete our consultation form on our website, humanrightsattorney.com. Thank you and good luck.